The historical theory of law is likewise another school of jurisprudence, and the historical theory of law was propounded by a German aristocrat by name Friedrich Karl von Savigny. Now, Friedrich Karl von Savigny propounded the historical school or the historical theory of law in order to counter the growing influence of the natural theory of law, which was aimed at overthrowing monarchs, kings, and queens in the 17th and 18th century Europe. Now, this theory of law, as propounded by Friedrich Karl von Savigny, postulates that laws should be strictly based on the customs and the traditions of the people. As a matter of fact, he developed the word Volksgeist, meaning the spirit of the people. So he was of the opinion that law should be comprised of that which binds the people together. He was very particular about whether the law has an historical touch or an historical relevance. In essence, he opined that for a law to be put in place, a historical backlash should actually be undertaken, or a historical appreciation of the society should be undertaken before such law can actually be promulgated. So, Friedrich Karl von Savigny was of the opinion that laws that deviate from the customs, from the traditions, or from the historical relevance of a particular society or a particular community should not obtain or should not be put in place. And this school of law is pretty much, explanatory enough. It says the central gravity of legal development lies not in judicial precedent, lies not in postulated theory, but in the society itself. So, looking at this over again, the historical school of law, as brought about by Friedrich Karl von Savigny, states that laws that dig deep into the historical context of a society, into the customs that are appreciated by the society, into the traditions that are revered by the society, should be what obtains as law within such societies. So it is very important to likewise understand that the historical school of law has certain criticisms too. And I would mention some of these criticisms briefly. So, what are the criticisms that have been levied against the historical school of law? So, one of these criticisms is that where this theory of law is followed dogmatically, it could actually hinder reforms or ingenious changes that could be put in place in a particular society. Now, to bring back our memory lane, the historical school of law states that law should conform with the history and tradition of a particular people. So, law should appreciate the historical context and relevance of a particular community. Now, in a situation where the historical relevance of a community is largely considered before putting law in place, it may hinder new reforms. Now, as considered in the features of law, now one of the features of law is that law is rapidly changing. So, law conforms to changes that come with the development of the society. So, centuries ago, there were some things that are not vices or that were not in place. But now, laws have been put in place to make sure these things are regulated as they have come probably as a result of modernization in the contemporary world. So, in a situation where laws continue to rely on historical relevance or the customs and tradition, it may hinder reforms that may come onto a society in terms of ingenious changes, ingenious ideas, ingenious innovations. And this is one of the criticisms that has been levied against the historical theory of law. Another criticism levied against the historical theory of law is that now these laws that rely on the dictates of historical context may actually be contrary to public policy, natural justice, equity, and good conscience. Now, for instance, there's been a couple of policies in medieval practice, and as a matter of fact, in the past 50, 60, 70 years. And some of these customs are against good conscience, equity, and natural justice. So, in contemporary times, these customs are not considered or have been invalidated by the provisions of the Constitution. Now, there is what we call customary law. Now, for customary law to be, effective and valid, it has to pass through 3 tests, which is the repugnancy test, the public policy test, and the compatibility test. So, the repugnancy test is that whether such custom is not repugnant to natural justice. Now, the public policy test is that whether such law in place is not incompatible or is not negating what obtains in the general public. And lastly, the incompatibility test, whether or not such customary law does not invalidate what has been enacted by the provisions of an existing law. So that is likewise another criticism against the historical school of law, in that historical context or laws based on historical customs and tradition has a very high tendency of negating the principles of equity, natural justice, and good conscience.